Alrighty, it's 2 o'clock, so to respect your time, I'm going to go ahead and get us started right now at 2 o'clock. First, a quick housekeeping note. If you have a question, go ahead and find the chat and go ahead and type your question as we're going in the chat. At the end of the presentation, we'll have a question and answer session. If you didn't get to put the question in the chat, we'll open up the microphone so that you can go ahead and ask your question individually. Okay? So with that, normally we'd say put your cell phones on silent, but we don't have to do that now. So let's go ahead and get started. So I'd like to present shielding for uncertain and shaping for the uncertain and shaping your future. So today you'll learn about understanding the 5 documents that you need to shield you from uncertainty. We'll talk about the different uncertainties that are looming, both in the news now and things that we don't like to think about happening. We'll also clarify the characteristics of people you'll choose to have certain jobs to assist you in the event you need them. Also, you'll discover that you can get a tremendous peace of mind by having all of these documents already set up so that you can be relieved that if something happens to you, you're going to be at peace. You're going to be taken care of. So why should you listen to me? Okay, so you know, anybody can get on a webinar and talk about whatever they want, but it really matters when somebody has the background and the experience to back up what they're saying, what they're recommending. I'll go ahead and tell you a little bit about myself. I am board certified in estate planning and probate by the Texas Board of Legal Specialization. I'm the only board certified estate planning attorney for 150 miles from Laredo. Also, I've been in practice for 24 years. I've been, you know, November will be 25 years, so that's just right around the corner. I've also written a few books. I wrote The Roadmap to Rich. It is a book on entrepreneurship and real estate investing. My book, the book that I published last year, is The 3-Bucket Method. It is a book about asset protection, how to structure your assets and your business interests in a way that will be protecting you the most and provide you the best tax position. Lastly, The Texan's Guide to the Probate Process is a book that we have right now on ebook. It'll be out in print later this year. But this book takes you down the explanation of how the Texas probate process works. And if you find that it's kind of convoluted, it also gives you some ideas of how we can avoid the process completely in some situations. So as you can see, I've got a lot of backup and a lot of history and studying to be prepared for what we're about to talk about. So what are we going to talk about? What types of things should we shield ourselves from? What are the things that today's topic is going to really be covering and discussing the protections? Okay, so one of the things is a sudden heart attack or a stroke. I have friends and family members who have had strokes, and for quite some time they were almost completely unable to do anything. They didn't recognize anybody. They didn't know who they were. They couldn't even speak. You know, some of them have still had some paralysis to where it's difficult for them to move around. Some of them, it's difficult for them to handle complicated processes. So strokes can be very, very problematic if you don't have plans, if you don't have a way to protect you, that if this happens to you, how are decisions going to be made? Another really common problem is people text and drive, unattentive drivers. So if you are involved in an accident and there is, you know, a reckless driver, a serious accident can leave you physically incapacitated, and there could also be brain injuries and other, you know, bad outcomes from a car accident. Now, as you all know, here in Laredo, we have a lot of truck traffic. So a truck accident, if you survive it, can be very, very problematic for you. So these things are real things that can happen. Now, the next thing is what's on everyone's mind right now, you know, is contracting an infectious disease. Right now, we're concerned about COVID-19. We don't know how it will affect you. It could be mild symptoms and you didn't even know it, or it could be severe, or you could actually die from it. So if you're isolated because of this infectious disease, you could be in a position where you're not able to communicate your wishes, you're not able to communicate decisions in your finances or care for your children. So it's important that we, especially in this time, that we have these in place. Now, as simple as the seasonal flu can have the same type of outcome. It can develop into pneumonia. And so there's lots of different illnesses that can come upon us that will create a problem that we need to take care of. So some of the problems that will result is, how will your family know how to make decisions for you? If you get sick, do they know what you want? Do they know what limitations there are? If you're incapacitated and you can't talk and you can't communicate your wishes, how are they supposed to do these things? How are they supposed to talk to your bank and say, hey, I need to be able to write checks to pay the mortgage, to pay the bills, to pay the utilities? You know, those are real everyday things that you need to think about, because if you write the checks, you're the only one that signs them. Who else can take care of those things for you? Now, if you have minor children, who's going to take care of your children if something happens to you? If both parents are hospitalized, if both parents pass away, and there's nobody there, how are those minor children going to be taken care of? That's a real key thing. Now, we have a solution for you, okay? They are powers and directives. These are the 5 essential documents that you need. These are the ones that are going to provide you, if you're incapacitated, if you have gone to where you can no longer make decisions for yourself, there is something that steps in to be able to provide you that protection. Let me give you the list right now. Number 1, durable power of attorney. This is very much related to fiscal related, financial decisions. Medical power of attorney, healthcare decisions. Designation of guardian for your minor children. This takes care of your kids that are minors. Directive to physicians or living will. I'm going to get into this in a little more detail shortly. But it basically tells your family what you want in your end of life situations. And designation of guardian in the event of later need. This is the document that if things elevate to where you need to have a guardianship placed on you, you can pick who you want and not want. Now, let me jump right into the first document. Okay, the first document is the durable power of attorney. So this document will authorize your agent to act on your behalf on fiscal related matters. So this includes things like dealing with real estate, dealing with banks, dealing with insurance. So a lot of the fiscal related financial things that you deal with normally in your day-to-day life, this power of attorney will have these powers. They'll also be empowered to manage your assets and your financial affairs. Now, this is only while you're alive. It can be limited to a specific time period. So for example, if you're going to go into a surgery and you say, well, I want my my trusted advisor to be able to handle my finances during the month that I'm going to be hospitalized, so that once I'm out, this power of attorney then lapses. It can also be revoked at any time. So if the person that was your power of attorney has moved away, either philosophically, doesn't think the same way you do anymore, or geographically moved to another state or moved to where it's not practical for them to be your power of attorney, you can always revoke that power. It can also be limited in authority. So you can limit what your power of attorney can do, what your agent can do. It could be limited to, hey, you can only sign real estate documents for this particular sale. It can also be effective only upon your incapacity. You can pick if you want this power of attorney to be effective now or not until you're incapacitated. I have most of my clients choose to have this power be effective upon incapacity. Why? They don't want somebody else handling their affairs while they're still capable. There's a very few, and they tend to be the elderly clients that are pretty much done. Hey, I don't want to deal with writing checks. I don't want to look at the bills. I want somebody else to just be in charge of handling that. And they have a trusted family member that does it. That they make that power of attorney effective immediately so they can do that. Another thing is agents can work jointly. So you can have multiple agents working together. So it doesn't have to be just one person. You can have checks and balances with 2 or more people. All right, some characteristics of a durable power of attorney, the agent that you would select. It's going to be somebody that you trust, somebody who understands your finances. So you don't want somebody who is just not going to know what's going on. You want somebody who understands your philosophy on how to spend money. You don't want somebody who, money burns a hole in their pocket anytime they have access to it, because your money may wind up having that same fate. Also, you want to probably choose from your inner circle. You can, aside from a trusted family member, it can be a business advisor, your CPA, or a trusted attorney. So all of those can be characteristics of a durable power of attorney. Let me give you a hypothetical of how a power of attorney might really be important and key to protecting your assets and saving you from losing an opportunity. So let's say you have contracted to purchase a property for $100,000. And you then suffer a debilitating injury, or you're in a car accident, some event that incapacitates you. So you're now incapacitated. Right after you become incapacitated, Walmart announces that they're buying the property right next door to build a new super Walmart. Okay, so now the value of that $100,000 piece of property is $1 million, but you're still contracted at 100. Your seller would love to be able to take that back and say, hey, I'll sell it to somebody else for $1 million instead of forcing me to sell it to you for 100. So they can use any excuse to get out of it. Now, the excuse that they're going to be able to use is saying, hey, he can't come or she can't come to sign the closing documents. So sorry, since you can't close, I'm not willing to extend the contract, and that's it. The contract expires. Now they'll be able to sell it to somebody else. So you could lose potentially a $900,000 profit because you don't have a power of attorney who will be able to sign documents on your behalf. So that's a really, really important reason why you would want to have it. And there are many other reasons, but that's one that kind of brings home to the pocketbook as to how that can affect you. All right, the next document is the medical power of attorney. Your agent is designated to make healthcare decisions regarding your healthcare and medical treatment. This is effective only if you cannot make decisions or communicate your intentions. And it's a designation that can be revoked at any time as long as you still have capacity. Okay, so this would come into effect in a situation such as if you're incapacitated and there are two options or more than two options as to the treatment to follow. So the doctor may need for somebody to sign off saying, okay, if we do this conservative treatment, the chances of recovery are minimal. If we do a more aggressive treatment, the chances of better quality of life are higher, but there's a higher risk of it getting worse. So somebody has to balance and make those decisions. And if there's nobody to decide, sometimes time will pass and there's no more opportunity to make a decision. Now we only have one viable alternative. So your potential upside of being able to decide what gets done is important to have in place. So some characteristics of a medical power of attorney. You want somebody you can trust, somebody who knows how you feel about different healthcare options, different healthcare treatment. It should be a trusted friend or some family member who's in the medical field, because that way they have some foundation in understanding what the doctor is saying, so they can filter out a lot of the emotion in these cases. If you have a doctor or medical or nurse or other medical professional in your family, they may be the optimal person to do it because they'll understand and they'll be able to deal better with the healthcare providers. So I've given you the example of if you have to have a couple of their different options for treatment, you can select who you want, or they can select which treatment would be better for you based on conversations you've had, based on the trust amongst you guys. The next document is the designation of guardian of a minor. So this allows you to select who you want to be the guardian for your minor children. This is effective if you pass away and are the last surviving parent. This guardian can deal with school and hospital matters and other related matters, but this particular guardian would not be able to control the finances for your child. That requires a court-appointed guardian of the estate, and we'll talk a little bit more about that. But the important thing here is if something were to happen to you and you're not here, who's going to take care of your minor children? Okay, you need to have something in place so that somebody will step up to take care of them. Somebody's going to step up to set up, hey, where are they going to go to school next year? Where are they going to live? What's the housing situation going to be for them? Now, some characteristics of a guardian for minor children include somebody who is a family member who knows the children already. Maybe, you know, you've got a cousin that lives in town. They may be the optimal person, or a sibling that lives in town. On the other hand, you may not want your brother or sister who lives across the country in another state, who barely talks to who you don't get to visit with very often, because it'll be a big culture shock to your child. They're going to be pulled out from where they are. They're already grieving. They're already having to deal with a lot of loss, and then to be dropped with a stranger. It can be very difficult transition for them. You also really want somebody who's going to share your philosophy on parenting. If you are the type of parent who is very strict, and 8:30 is bedtime, and no matter what, that's the rules, then you want somebody who's going to have a similar philosophy as far as that structure. If you're a little more laid back and you don't feel like that is an important thing, you feel like, you know, let's just be relaxed and let natural sleep patterns develop, then that's the type of person you want to have that role, so that your kids, again, don't have that culture shock of, hey, I used to be able to stay up till 10 or 11 whenever everybody was going to sleep, and now I'm forced to go to sleep early, and I don't like it. I feel confined. I'm not in jail. So it can create these problems. And most importantly, have a conversation with the people. You want to make sure you're communicating, so that, number one, they know that they need to come in and step up and take that control with the children. Also, you want them you want to have this documented, so they don't have problems legally, especially if they're not a family member. It could be that it's your best friend, that you guys are always spending time together and you have kids of similar age, but you know, your brother or your parent may come in and say, hey, wait a minute, I'm family, I should be the one in control. So we want to make sure we talk to people so that we avoid misunderstandings and we avoid fights, especially with kids involved in the middle. Okay, the next document is Directive to Physicians. The Directive to Physicians is also known commonly as a living will. This is where you give your last, your final wishes. So while you're alive, it allows you to express your decisions in the last moments of life, when you are either in one of two conditions. One is if you are in a terminal condition from which you're not expected to survive for 6 months, or an irreversible condition where you cannot care for yourself or make decisions for yourself, but you're being maintained. You could be maintained indefinitely, maybe in a vegetative state or some other artificially medically maintained situation where you can't make decisions, and you're not going to come back. Now, there are two choices to be made for each of those scenarios. So the first choice is remove all treatments except those to keep you comfortable and allow you to die as gently as possible. So that's pull the plug on everything. Just let me die as gently as possible. Give me the pain meds and remove the ventilators and those things. The other choice is, hey, I want to go out fighting. I want you to maintain all treatments, keep them on me no matter what, until the last minute where the machines can't do anything. I want you to keep me going. There's no wrong answer. It's a personal decision that everybody has to make on their own. So you know, you get to make that. The beauty is this takes the burden off of your family members. It takes the burden off of their decision. Hey, do we continue keeping mom or dad in this condition? They're not going to get better. The doctors have already told us that there's nothing, there's no way they're ever going to come back or recognize us or anything. you can take the pressure off of them and say, look, this is what I want you to do. That makes life a lot easier moving forward for the people who get left behind. So it's a very important document to have. Okay, so what you should have in mind when you're doing your living will is what are you willing to have done if you're in any of those conditions. This could be as easy as little as, do I want pain medication? Do I want a feeding tube? Do I want to get antibiotics? Do I want to have dialysis done to me? So there are different things that you may say, well, continue doing these things, but I don't want these other things. You can specify any limitations that you want to have, things that you consider, this is going to keep me comfortable. So that's the next point here. What's going to keep you comfortable? Pain medications. Are you going to be made uncomfortable if you have a minor surgery or a major surgery or a procedure? Those are all things that you guys would need to consider when we're doing this. Also, you need to evaluate or self-assess your pain threshold. Some people are highly sensitive to pain. Other people have a higher pain threshold. So you kind of need to figure out where you're at and what kind of limitations do you want to put on what pain level you want to suffer. So that's the living will. Next is the designation of guardian for you. So if you become incapacitated and it gets to the point that there needs to be a guardianship, you can select who you want to be your guardian. Who's going to be your guardian of the person and of the estate? And I'll talk about that in just a second. But you can select who you want to be your guardian, but you also can select who you don't want. My wills professor, Jerry Beyer, used to say, every once in a while you'll find that there is an evil relative in the family, and you don't want them to be your guardian. Now, this person will act for your benefit under court supervision, okay? Now, if a guardianship is placed on you, the powers of attorney, both medical and durable power of attorney, will be dissolved. So those will no longer have effect. So we want to make sure we coordinate those. So let's break down these two types of guardians. The guardian of the person is a guardian who makes fiscal related decisions for you. They are the ones that make sure that you're eating, you're sleeping, you're taking your medications, you're bathing, you're seeing the doctor when you're supposed to. So physically taking care of you. They don't have to do it literally themselves, but they are responsible for those things to be done. So they can hire somebody to take care of you, but they're responsible for whatever your care is. The guardian of the estate handles fiscal matters on your behalf. So this is this person will handle the finances. People who owe you money, making sure they pay. People you owe money to, making sure you pay, and maintaining those financial relationships and outcomes. Now, some characteristics in choosing a guardian, you want to have the guardian of the person, you want to have that aligned with the medical power of attorney. The medical power of attorney is going to dissolve. So the person who's going to have your care, you want them to be, you want to line that up with the guardian of the person. So it might be the same person that is the guardian, that's the medical power of attorney and the guardian of the person. So, because those roles are very similar. Next, the guardian of the estate should also match with the durable power of attorney, because those are both the financial decisions. So you want there to be continuity. If one is dissolved, you want to make sure that the guardian that's appointed matches up with who's going to handle your fiscal matters, your financial matters. So those are some of the things that you want to take into account when you're doing that. And it goes without saying, you want somebody who is a trusted person, who knows what you want and what kind of treatment you want, how you want to be treated, and how you want your finances to be handled. So in summary, the powers and directives are the durable power of attorney that will handle fiscal related things, medical power of attorney to handle your healthcare decisions, a designation of guardian for your minor children to take care of your kids if you pass, and the directive to physicians or living will to help take the burden off your family when you're making those important decisions. And lastly, selecting a guardian that you want in case there ever does need to be a guardianship placed on you. All right, so with that, we'll open it up for questions. So I don't see any questions in the chat. If you have a question that you'd like to ask, we can go ahead and do them here through audio. If you just go ahead and unmute yourself, and let's just try to do it one at a time. So if somebody unmutes and starts talking, if you could just wait for them to finish, and I can finish my answer, and I'll be happy to stay on as long as we need to answer your questions.
Hi, Mike. This is Ann Kaufman in McAllen.
Hey, Ann, how are you doing?
I'm good. Can you hear me okay?
Yes.
My question is, when a power of attorney is in, say for someone who has had a stroke, and the victim has mental capacity to be able to make decisions, I find myself being the agent and wanting to do one thing, and the client do things also. Does the POA take precedent over the individual?
Okay, so you were breaking up a little bit, but I think I got your question. I'm going to repeat it just to make sure we're all on the same page. The question is, if the example is there's a stroke victim who's somewhat recovered, they still need help, but they do have capacity to, they understand what they're doing, they're able to make decisions, they may just be more physically challenged. The question then is, if the principal, who is the person who made the power of attorney, has a different preference to the person with that has a power of attorney, which one controls? Okay, so in that particular situation, the principal would be the one who would have priority, because they would be able to revoke the power of attorney if they wanted to. Plus, the agent is limited to doing only what the principal would be able to do, or what they would do if they were not incapacitated. So in this situation, I'm assuming that it's a power of attorney that is not dependent on capacity. So you would want to, if you were going to be, if this is a client of yours, what I would recommend is having the principal maybe limit that power of attorney, create some limitations there, or give you some specific instructions. Ultimately, they are the ones that make the decision. When an agent makes decisions that are outside of what the agent wants, they're exposing themselves to liability. So they have a fiduciary duty, which is a duty that results from a close personal relationship of trust. So the person I would listen to and do what they say, unless it's really just off the wall, would be the person who's the principal, who the person with the stroke that is still able to communicate their wishes.
Okay, thank you. Yes, thank you very much.
Sure. Does anybody else have any questions?
Hi, this is Maria Moreno.
Yes, Ms. Moreno, how are you doing?
Really, really well. This is very informative. I'm in awe. I was like, wow. Just a minor question. My sister and I do have a durable power of attorney for my mother. I know it can be revoked by what I just learned right now. My mother was diagnosed with Alzheimer's last summer. How does that affect it? Can she still make those decisions, or?
Right. Depending on her level of capacity, if she's already been diagnosed with Alzheimer's, chances are that she won't be able to revoke the power of attorney. So it's very good that that power is there, because she may not have capacity to actually enter into any agreements.
Okay.
And so she probably wouldn't be able to revoke the power of attorney either.
There's no problem between us right now with that. I was just curious right now because of the diagnosis from last year. Thank you very much. That helps me.
Sure. Any other questions? Vicky, any questions?
Hi, Mike. How are you?
Good, good.
I have like a million questions, but I don't want to take up too much of your time.
All right, just one or two.
Yeah, I look forward to, as soon as all this passes, to go ahead and set up a meeting and start getting power of attorneys for my business as well. I need the structure set up for that. So I look forward to going and working with you and your team.
Well, we're working, just to pause you right there for a second. We are doing meetings by Zoom.
Okay.
So anybody who can't come into the office or doesn't feel comfortable, going out in public, we are doing a lot of meetings through Zoom. You don't have to be too tech savvy. If you have a smartphone, we can do a meeting. So we're able to do a meeting, and if you like, I'll ask Albert to go ahead and set up an appointment for you.
I would appreciate that. Yeah, we're at a good time then. Let's do it.
Yeah. All right, go ahead. Now ask your question.
No. I just need to get everything ready for my business, since we're in partnership with Claudia, and we need to set up, if something were to happen to me and something were to happen to her, whose interest is staying in the business, or if her family is still going to stay, collecting profits and all that. So I look forward to getting all that taken care of, because believe it or not, we've grown in the last month and a half, and, unexpectedly, not trying to, go out and prey on people and there's insecurities at this time, but it's just, we're able to help a lot of people. And so we've grown in this time that we've been in confinement a lot. So,
right. So Vicky, I'm gonna go ahead and take advantage of your comment and turn it into a question. So
yes, sir.
when you have a business with
Yes.
a partner, there are things that you can put in place now, so that way, if one of you passes, you can go ahead and continue with the business, depending on what you want to do.
Right.
On the one hand, you may say, well, me and my partner are get along great, but I don't want to work for her husband or for her kids, or, I don't mind working together because we're both rowing the boat, but
Right.
I don't want to row the boat for somebody who's just going to be on for a ride. So that's where we can create buy-sell agreements, and it's a great opportunity for both parties. The family may not want to be involved in the business, but they could probably sure use a payout of cash, so that they can have cash instead of shares in the business. So we can set up agreements where that the family has to sell the shares either to the company or to the other partner, and then the company or partner gets proceeds from an insurance policy, which then basically funds that buy-sell and gives the family the cash, and the company or the surviving partner now has all of the shares in the business, and they continue operating for themselves, and they've been able to pay off the shares of the deceased family member. So a lot of good opportunities available in planning for succession.
That's great. I appreciate it. We'll do that then, a buy-sell agreement.
All right.
Yeah.
Thank you.
Thank you, Mike. I appreciate it. Thank you, Kat.
All right. Any other questions? All right. Then if there are no other questions, thank you very much. I'm looking forward to doing more of these sessions on different topics. We'll have a recording of this available for you soon on our different media platforms. And I look forward to visiting with you in person and maybe addressing some of the needs you may have and some of the things that we can do for you. Thank you.
Thank you.